Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Nipasa, and I'm going to be with you for this next hour. I hope you're very, very excited about today's session, just like I am, because we are going to be joined by attorney Chand Parvatheneni from SPB Law Firm, Dallas, Texas, very, very soon. But before we welcome him officially to our show, and also, we start off with today's discussion, I had this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, with that in mind, friends, I hope that you will enjoy this whole session that's lined up. And also, if you haven't as yet already subscribed to our channel, don't forget to subscribe now. I wonder what you're waiting for. Subscribe to us and also share this link, share this content with your friends and family who can benefit most from this. So, yes, and also our handle is at Immigration Talk Show. Check us out on YouTube, and we are also there on LinkedIn, Facebook, X, and on Instagram. So, connect with us, stay in touch with us, and stay updated because we provide you with the latest updates on immigration. So, that said, yes, today we're going to discuss on a very important and a very relevant topic. And if we can see, it's going to be about how can H-1B and F-1 visa holders stay compliant with US laws. I mean, laws are laws, and we really need to abide by each one of them. And every day there are new updates. I'm not saying rules are changing, but there are additional things to keep in mind. So, we are going to discuss all of that today, friends. And yes, without further ado, please help me welcome Attorney Chand Parvatheneni from SPB Law Firm, Dallas, Texas. Hi, Chand. How are you doing today? Thank you so much for joining us.
So much for the invite, and hopefully we'll have a very productive session where we educate all the users, uh, all the non-immigrants and immigrants who are in the United States on the laws and recent changes and what's going on. Because the goal is we want to stay compliant with all U.S. rules, laws, and regulations, and laws keep changing all the time. And saying that I'm not aware of a rule change is not really a defense. And what that means is we just want to make sure people are educated, people know what's going on, and doing so, they follow what the government wants, and then that way they're not jeopardizing their careers, and then just keep moving ahead.
Correct, correct. Absolutely right, Chand. It's so important to abide by the laws, and telling the officers that you didn't know, it's not going to be an excuse. You're never ever going to be excused for, even if you unknowingly did something that was against the law. So I hope that you're staying alert, keeping yourself updated, watching the news, and also watching our space, because here at Immigration Talk Show we keep updating you with the latest. So check out our content, check out our channel, and yes, stay in touch with us. So, Chand, from today's session, we are expecting a lot because H-1B, it's definitely the season. F-1 visas also because, yes, as you know, there are quite a bit of students out there who are also facing some changes in their lives. So, all that in mind, what's happening around uh, SPB law firm, and also what can we expect from this session?
Sure. And so I think the last 10 days, I would say last probably 2 weeks, starting from the first April 2nd, what we've been noticing is a lot of students, all of a sudden, they started getting emails from the consulates saying they have to self-deport. And then the universities saying their service has been terminated. So all of a sudden, we have seen these issues We don't really have a precedent for these kind of things in the past. And then when we saw what's going on, we started talking to a lot of students who got caught up in this unfortunate situation. What we found out is uh, they had some brush with the law, and maybe they're innocent, maybe they're guilty. But what happened is, anytime somebody has a brush with the law, so for example, somebody caught up in some incident, they gave their fingerprints, and eventually the case got dismissed, or maybe they got convicted. So in all kinds of circumstances where somebody had any kind of a brush with the law, what started happening is the consulates, Department of State, has started revoking the visas. Schools started saying that, hey, your service is terminated, you might have to go for a visa stamping. So what this means is, in immigration law, we have crimes which make people deportable. People can be removed for certain offenses. And recently, what we have started seeing is, it is not about just those offenses. It is zero tolerance. And zero tolerance means any kind of a crime. If you are involved in some kind of an infraction, you could be removed. And that's the message that's going out. And from our perspective, the government makes the rules. The executive body has the power to make rules. The courts have power to make the rules. The legislative body has the power to make rules. And what that means is, people have to ensure that all the rules and regulations are followed. And if it is zero tolerance, we can't take a chance. And what that means is, people have to be ever cautious. Even simple things like speeding, reckless driving, driving without a driver's license. So even these kind of things are very serious, and people just have to make sure that, even accidentally, don't make any minor mistake. So things like driving without insurance, for example, that could cost somebody their immigration career. Driving without a license could cause a problem. So every infraction is an infraction, and what that means is, it's a good time for all of us to kind of take a step back, because people are busy in their careers, people are busy in their studies. Sometimes they overlook minor things, and this is a time where everybody should understand that even minor things like driving without a license, uh,
Mhm.
they are very important. And like public intoxication is where people get drunk, they're not driving, they're walking on a public street, even that is illegal. So there are laws against intoxication, reckless driving. So when people come and say, hey, it's a traffic infraction only, it's still an infraction. So it's a good idea, good time where we see what's going on, what kind of issues are being raised by USCIS, Department of State. And again, postings, social media postings, political postings should not be done. Okay, because whether it is talking about politics in India, talking about politics in Israel, or talking about politics in US, if somebody is in US has a foreign policy, and if some political posts are running contrary to the US foreign policies, tomorrow they will be at risk. So what that means is, people have to be very, very cautious, very respectful of the US foreign policies, very respectful of the local culture. And their social postings should not be doing anything to kind of insult somebody, maybe like putting a comment, maybe putting a like. So these kind of things, people have to be overcautious, and people have to be professional. So that's the idea. Because people, we are not saying people don't use social media, but don't make any harassing comments, don't make any political posts that could lead for the government to come back and say, you have done something wrong. USCIS has also announced that they're using various tools to look through social media. So they have very, very powerful tools and software tools and computer systems that can dig through these things and look exactly what they want. So a good time for everybody to revisit your social media presence and make sure you're always respectful. And the thing is, we are living in a democracy, so nobody is saying don't talk. Just don't talk anything that is insulting to the local culture, local traditions, and the foreign policies of the country. No country wants somebody to come inside their country and then talk bad about that country. And that is what we are saying. Just be cautious, be professional on the social media. Don't get into any confrontations on political things, and you should not see any issues going forwards with your visas or anything of that sort.
That was very insightful. I mean, friends, you can only imagine if this was the introduction, then you've got to stick with us because we have so much more information coming up for you here in the next 40 minutes or 50 minutes or so. So, thank you so much for joining us, each one of you, wherever you're watching us. Our handle is at Immigration Talk Show. If you haven't as yet subscribed, subscribe now. And it's going to be a good session today. I totally promise you. So, also, at the same time, I'm going to say hello to Rag. Thank you so much, Rag, for joining us once again today, also. So, hello, Nipa plus Chant. Good to be here. Good to have you too, Rag, and I'm looking forward for your questions already. And Drive 10, good to see you again. Thank you so much for joining us as well, because I think I remember this name for sure. And also, we sort of touched on Drive 10's question because we just spoke about social media. So we are going to speak about it. Yes, we are. So stay with us, and Rag will take your question a little later. But thank you, Chand. I hope, Chand, you're ready for our questions now.
Yes.
So, let's start with the employers. What are some of the most common mistakes that you see, employers making when filing H-1B petitions, and how can these be prevented right from the very start?
Sure. Sometimes it is not just criminal infractions, but also sometimes mistakes done by the employer could come back and haunt the employees. And when somebody is filing an H-1B, the company is filing an H-1B, the first and the foremost thing that the company has to do to even start the process is to file a labor condition application called the LCA. And this LCA is very, very, very important. And pretty much this is the first step. And if employers make a mistake in the LCA, it could come back and haunt the employees, because if there is an FDNS site visit, if there is a USCIS site visit, things don't line up. The employee is going to be having a problem. And how do you prevent it? So you always have to triple check your job locations. So what happens is when the company is filing for a H-1B, on the LCA, the work location is a mandatory thing. And people sometimes make an accidental mistake because sometimes people are working at third party locations, so the company accidentally puts the wrong address. So things like putting a wrong address, or sometimes putting a wrong job, because if the employee is working as a software developer, for example, if the company filed an LCA saying a database administrator, and tomorrow when there is an FDNS visit, they go to the client side and the client confirms, hey, this person is a database administrator, and the LCA says software developer, could lead to a problem, could lead to the H-1B getting revoked, which eventually means that the employee is going to face problems. The next most important thing is wage levels. Every LCA will have the wage levels. So if some employer is using the wrong wage level, so they're saying it's a wage level 1, for example, a junior level position, file it as a wage level 1. Tomorrow there is an FDNS visit, and the officer is visiting the client, and the client says, hey, this position requires 3 years of experience. We have seen, I mean, again, this is first hand information, I have seen notice of intent to revoke cases getting revoked because the USCIS gave this notice and proved that the wage level is wrong. So inaccurate wage levels are also causing problems. So sometimes you have to make sure you check your LCA. And the good thing is, by rule, by regulations, every employer has to provide a copy of the LCA to the employee. So it's a good idea that employers and employees are looking at the LCA, because if one accidentally makes a human mistake, the other side is catching it. So employers and employees, always take a look at your LCAs. Just make sure there is no mistake. And employees should have a copy of an LCA, and this is a mandatory thing. Every employee should have an LCA copy. No employer can refuse that because it's in the regulations. The rules say that the employer has to provide a copy of the LCA. If not, they're not complying with the H-1B program. Okay, so the first and the foremost thing, ensure you have a copy of the LCA. Next thing we see is mismatch in the job requirements versus beneficiaries' qualifications. So USCIS might deny petitions if the job truly is not a specialty occupation job, or the employee's degree does not align closely enough with the job duties. So when you talk about employee's degree, USCIS fortunately lets us use either the degree or the combination of degree and work experience. So theoretically, the degree plus work experience, or the degree, the equivalent of these things, should be relevant to your job, and your job should be a specialty occupation job. So what the company has to do is, you clearly define the job duties, you clearly define how you require a specialized degree, not like any random degree, like say a business degree or a regular engineering degree. That is too generic. You have to be specific what kind of an engineering degree you require, and so on. So how do you prevent it? Always clearly define the job duties, and that is something what the employer will have to do when they file the petition. Make sure they define the job duties. If not, tomorrow you might get an RFE, you might get a bad RFE, the case could get denied. And next most important thing is, every employer, not the employee, the employer has to maintain something called a public access file. So a public access file is something where anybody in the public, like a random person can walk into the company and say, hey, I know that you're filing for H-1Bs. I want to see your public access file. And this is something what the public can do and the company cannot refuse. The public should be allowed to inspect a public access file. And what that means is the company should always have a public access file. If the company does not have a public access file, again, they're not being compliant with the H-1B program, could lead to audits or penalties on the employer side. Again, public access file is very simple. All the company has to do is maintain the public access file. Public access file means employer will have a copy of the LCA, will have a copy of the wage info, will have a copy of the notice postings. And these things are available in the office for anybody to come and inspect. So the way to solve it is have an internal compliance checklist. Every time some H-1B employee is hired, the employer should be doing this thing. If not, if you don't have public access files and the company gets audited or penalized, tomorrow it's not only the company, it's also the employees working under the company. They will be impacted. So what that means is every company who's filing for H-1B, public access files, this requirement is a very, very, very important requirement, and companies should do it. Very important. And next major thing we see is failure to notify USCIS of any material changes. So if you're working for an employer on H-1B, if you have material changes, for example, you got a promotion, you got promoted from being a software developer to a software manager, for example, or you're moving your project from one client location to another client location. And what that means is you're moving far. So you're working in Dallas, and tomorrow you have a new project. Your company is saying you have to work from Austin. So that is a material change. So if you have material changes, the company has to file an amendment, and this amendment has to be filed before the change happens. And this is very important because if USCIS finds out down the line, how do they find out? Tomorrow your company is applying for extensions. Tomorrow your company might have a site visit. So multiple things could happen. So if you do not notify USCIS of a material change, tomorrow USCIS could cause a problem. And all that means is employer be diligent, file amendments timely. So these are some of the things that on the employer side, people take steps to ensure you're in compliance. And if employers do that, employees typically don't have a problem. So from the employee's perspective, if you know that there is a material change in your employment, always talk to your employer, make sure the amendment is done. Always make sure you know what your job duties are, very clear job duties. Make sure you only do those job duties. Make sure you have a copy of the LCA, review your LCA. And these are steps to ensure that you are in compliance. When I say you, it's the employer and the employee are in compliance.
Thank you so much, Chand. I mean, though that was very descriptive, very detailed, and I really hope that folks out there took points down, took notes because they were very important. So, thank you, Chand, for taking that up. And quickly, I'll also say hello to Alicia. Thank you so much, Alicia, for joining us. We will take up your question. Stay with us. All right. So now moving on, Chand, I also wanted to know if the job description, if it plays sort of a big role in meeting the specialty occupation requirement for H-1B, because we have been speaking in our previous episodes also about this, about the change of specialty occupation definition and, how important it is to give a very, very detailed explanation about what your job, requires you to do in that period of time that you're going to be in the US. And if you can also tell us what makes a strong job description in the eyes of the USCIS.
Absolutely. And again, you're right on this topic. So the job description, if you ask any attorney who does a lot of H-1Bs, what is the heart of your H-1B petition? It is the job description. The job description is very critical. Once you have the LC and everything right, how you go back to USCIS and present your role, the job description, that is most important because that is where USCIS gets to decide, is this even a job that requires H-1B? If the job is not a specialized job, H-1B cannot be given. How does USCIS know even if the job is specialized? They look at what the job description is. So the job description is most important to prove the specialty occupation requirement because USCIS looks at the job duties. That is how they know what kind of a degree this job requires. So if the job duties talk about, say, healthcare, they kind of will be able to kind of make that connection between the healthcare degree and the job. If you have a lot of if you have the duties that talk about software development, that is when USCIS will be able to make that connection and say, yes, we understand that this degree in software or IT is a requirement. So the job description every company has to be very, very cautious. And what happens is a lot of times companies give a very, very short description. They give like 3 lines, 4 lines, and just assume that USCIS will understand it, because companies typically, the companies that typically I work with, they're very technical in nature. So for them, English writing long sentences, that is not what they do on a day-to-day basis. They're more about coding. They're more about technology. So for them, what they do is they just give some very, very generic lines, which probably only specialized people like IT folks will understand. And the goal of the job description is we want non-technical people to understand. So what that means is, sometimes, to give an example, the companies are not very specific. They'll simply say the job duties are the employee will be responsible for software development tasks, or the employee will be involved in software development. So, for example, that is the line that a lot of companies will give, because they are technical companies. They understand. They assume that people will understand what that means. And from a USCIS perspective, that is a weak example. If you say involved in software development, that is too generic. Responsible for software development, that is too generic for USCIS. So what USCIS expects is a very detailed explanation. For example, you have to reword it as design and implement, for example, scalable Java applications, integrate with APIs, optimize the database performance using so and so technologies, and so on. So rather than just give like a simple generic line, you have to get more into the details, expand the job duties, and explain it a little bit clearly. USCIS wants to see a little bit more elaborate explanation. And why is it important? The reason is, the more specific and technical the tasks are, so if the company gives more detailed and elaborate and specific tasks, then it is easier for the USCIS to link it to a specialized degree, like say in this case, computer science or engineering, and then go forwards. So the basic idea is, don't give like a very short description, kind of expand it as much as possible. And then the next thing is a breakdown of the job duties. So don't give like just 3 or 4 sentences and say that is my job description. Try to give as detailed as possible. And what that means for us is, I always say, at least try to put 15 lines about your job duties, 15 bullet points. Don't just give 3 or 4 bullet points and say that that's it. That is what the employee will do for the next 3 years, because you are asking for an approval for the next 3 years. So try to kind of elaborate each and every duty that the employee does. So it's pretty detailed. And to me, if you're at least giving like at least 15 bullet points or more, it kind of gives a clear explanation. Each and every task is kind of highlighted. So that's one thing. And also always show the link to a specific field of study. So you have to kind of make that connection. So it is not just any generic degree like management or any generic engineering field, but a very, very specific field like computer science or computer engineering, IT, or maybe statistics, maybe economics, and so on. So be as specific as possible to the degree. Don't give a generic degree. And again, a good idea is to talk about all the technical tools and all the methodologies that you use. So if you're using a lot of tools and a lot of technologies, make sure each and every tool is highlighted and given to USCIS. And also, generally, what the companies do as a part of the filing is they also show the own it statements. Own it is there is a website called ownitonline.org. That is pretty much what is used by USCIS and DOL. So this ownitonline.org, if you have not seen it, go online and go see it, because your LCA, everybody's LCA on H-1B, you'll have a code, own it code. And if you go to this website, ownitonline.org, you can plug in that code and see what are the job duties expected in that occupation. And that is something what USCIS heavily relies on. So that is very important. And there's also something called Occupational Outlook Handbook. You can Google this link, Occupational Outlook Handbook. So what happens is, if you put in your occupation name, this Occupational Outlook Handbook, it will tell you if the industry standards normally requires a bachelor's degree or not. So normally what we do as attorneys is we go to that link, we plug in that occupation and see what the requirement is. So tomorrow, if your employer is filing H-1B for you, it's a good idea for you to go and check what this Occupational Outlook Handbook says, or what ownitonline.org says. And if these two say that a bachelor's degree is not required, more than likely USCIS is going to come back and say your job does not qualify for H-1B. So we always refer to these two links to see if the job qualifies for H-1B, because these links will tell you if the occupation requires a bachelor's degree or not. And finally, another thing that people should do is always put the breakdown of job percentages. For example, IT, say the employee is putting 30% of his time on software development, 25% of his time on system architecture, maybe 20% on code reviews, 10% on deployment, for example. Give this percentage wise breakdown. It's always a good idea because this shows the depth and the nature of your job and avoids specialty occupation RFEs. And again, we don't really see, we are nowadays we don't see a lot of such RFEs because in general companies make sure that the jobs are specialized. That being said, it is always a good idea to give this percentage breakdown and ensure that there are no complications, no unwanted RFEs as your H-1B gets processed.
Right. Thank you so much, Chand. And that was another very detailed explanation. And I hope that friends out there are taking notes. And you also took down the two websites, if you can quickly name them again, Chand, to check their own it codes. And
Sure. So the first link that I think it's a good idea for everybody to have is onetonline.org. So it is ONET online.org. And it's a very important link. It's pretty much every immigration attorney or the employers will use. And you can plug in your ONET code. So when you have your LCA, if you open up the first page of your LCA, you will see something called ONET code. For example, software developer is 15-1252. So everybody's occupation is different. So you should know what your ONET code is, and this website will kind of give you the mapping. It will tell you what exactly are the job duties expected in that ONET code, how much percentage of people in that occupation have a bachelor's degree,
Mhm.
and what is the job zone, what are the kind of the requirements. It will give you an industry picture and so on. So when you have this report, it is kind of easy to go back to USCIS if there is ever a problem. And in general, it is also always a good idea for you to see what are the requirements of that occupation. So you pretty much know what's going on. Your role is currently aligned to that ONET code and so on.
Thank you, Chand. Thank you once again. So I hope that that's highlighted, friends, and you keep that in mind before if you get confused or you think that you need a direction, I think this is the site that you need to visit. So thank you, Chand, once again. And I think right now we should take up our questions from our audience because they have been waiting. So let's start. Let's take up Drive Ten's comment first. Hi, Chand. Have you heard of anyone getting into trouble because of their social media?
Sure. So I talked to almost close to 30 to 40 people in the last 10 days who had their services
Whoa.
terminated. And majority of them were from India because we talked to a lot of people from India. I had talked to one person who's from another country, Latin American country. I talked to one person who's from Africa. So we are like seeing people from multiple countries. Uh, and when the consulate sent them an email, and when the school sent an email saying the service is terminated, so they are giving the reasons. It's a very generic reason. So the pretty much everyone that I have seen, it says that you have been identified in a criminal record. That is pretty much what I have seen. And when we talk to these students, what exactly is the criminal record? So all of them, the commonality was all of them had to go to the police station or some place and give their fingerprints. So later on, some of them were proved innocent, some of them were proved not guilty. But the commonality was there was a record, and that record is they went to the law enforcement agencies and they had their fingerprint given out there. And in terms of social media, I personally have not talked to anybody, but there are news out there, and there are people like people who have been involved in Palestine protests, and it's in the news because these are confirmed news, and people are talking about just because they put some comments in the social media. Now their visas are revoked. We're also talking about people with green cards. So there was a case, Mohammed Khalil, who was involved in Columbia University protests. There was another person from Columbia University who was about to give his citizenship interview. He was stopped by the police, stopped by the law enforcement, and arrested. So social media. So we have confirmed news that people who had issues in social media, they are being having issues. Again, the thing is, generic advice is follow the government rules, follow the government regulations. Don't do anything contrary to what the government expects you. So just stay away from it. Okay, so that's pretty much what I can say at this point of time.
Thank you so much, Chand. Yes, and Drive 10, thank you for your question. Now we have Rag. Rag has a question. So he's asking, what happens to a concurrent H-1B if the petition is granted but goes unused?
So if a concurrent H-1B is approved, typically what happens is the second job. So it's a concurrent job. The government expects you to work on that job, and tomorrow there can be a site visit. And when there is a site visit, what typically happens is they ask the company, "Are you paying the employee, and what's happening, and so on." So if the petition is granted and you're not working, so what we tell is the company should probably revoke the H1, because if you don't, there could be a site visit and the officer could complain that there is an approval and somebody is not being compliant with that H1B. So to avoid issues, if that H1B is not being used, it's a good idea for the company to revoke that concurrent H1B, because if not, the company has a liability. So the company will have to pay and the employee has to work. So to avoid that liability, if it is not being used, it is always a good practice to notify USCIS that you want to withdraw that H1B. And if the company withdraws it, you should not have any problem because you notified USCIS.
There you go, Rag. Thank you so much, Chand, for taking that up. And Rag, I hope you've gotten your answer. Now let's take up Alicia. Alicia is saying, Chand, I'm on H-1B and planning to switch employers. How safe is it to start working on the receipt notice given the current delays in processing?
Sure. So if we talk about H1, again, I think there's a lot of rhetoric going on that things are, I mean, like some things are bad, but overall for H1B, we are not seeing USCIS do anything different. So USCIS, again, they're approving cases, there is premium processing, and we're not seeing any uptick in RFEs. Again, I think people following proper rules and regulations, we're not really seeing any bad RFEs or any change in the percentage of approvals. So to me, if the company is good, if your job offer is bona fide, and you're doing everything that says that you're following the rules, to me, it is still safe to work on a receipt. That being said, personally, I would be more confident if I get an approval. And what that means is you can simply ask for premium processing, try to get an approval. So that way there is like no uncertainty, there is no ambiguity. So premium processing is still available, and in general, I mean, again, if things are being complied with, we are not seeing any changes. I mean, again, it's not like you're seeing denials. There's nothing like that. I think things are good. The only issues that we have been seeing is people with any kind of criminal records. That is the only thing that I've seen in terms of legal immigration. Otherwise, I think things are normal, and there is no issues in terms of H-1B approvals. But definitely a good idea to kind of upgrade your case and get an approval.
Thank you so much, Chand, and all the best, Alicia. I think you have an option there. So now let's take up Shalini. Hi, Shalini. Thank you so much for joining us on YouTube. And Shalini is asking, are H-1B petitions being filed for fiscal year 2026? What is the trend?
Yes, we are working on a lot of cases for H-1B fiscal year 2026 filings. So the lottery happened last month, and we've started filing. And the trend in general is, in terms of H-1B, in terms of adjudications, we are not seeing any different trend. That being said, what is different from last year versus this year? So this year, new rules went into effect in January, and the new rules require that upfront you have to show proof of bona fide job offer. And what that means is you have to show USCIS with the filing what your assignment is. And what that means is maybe you have to include contracts, maybe you have to include the client letters, or so on. So the trend again is, I think this year, I think definitely there are a lot less filings than last year, clearly. Reason for that is probably because the fee increased, the registration fees. This year it was $215. So I think in general, the number of filings came down. The percentage of selections was a little higher than last year. And we are seeing people file because, again, there is still a lot of requirement. That being said, things are definitely a little bit different from last year in terms of the demand. That being said, I think the trend is there is still time till end of June. People have definitely started filing. We ourselves are working on a lot of cases right now. But again, historically, end of May, June is where there is a lot of traction, because then people realize that there is a deadline of June 30th. So more and more people start filing. But again, we are not seeing anything widely different in terms of people who've already been selected. Because if people got selected, the companies want to kind of finish off the filings. And that being said, end of June, I think we'll have more information. And if enough people do not file before the June 30th deadline, there could be a second lottery. So what USCIS would do is, in the month of July, they will go through the statistics, see how many slots are not filled. And end of July, typically, or max first week of August, they will announce whether there is a second lottery or there is no second lottery.
I think we are all excited for that already. We get questions if people we are going to have the second lottery, but we'll just have to wait for now. And friends, stay with us because we will keep you updated if there's going to be one for sure. So don't forget to subscribe to our channel if you haven't as yet, especially Alicia. Then we have Shalini, Drive 10. Thank you so much, Rag. I know you have subscribed, but do share our content with your friends and family who will benefit with our content here. And I hope that they can join us too. So now let's go on, Chant. Let's take up Nandini's question. She's asking I-140 RFE received saying received potentially adverse information about beneficiary. To process your application, we need updated address so that we may collect biometric data.
Yeah,
Worried
and
because pending, yes.
yeah.
Sorry, I'll just
So
complete. Okay, Chant, go first.
yeah, I see this is a very, very recent RFE that just started last week, and we're like actually educating a lot of our clients about this kind of RFE. I've seen two RFEs, one for H4 and one for a H-1B application, saying the exact same thing. It's like a one paragraph short thing, and saying there is some adverse information, and saying we need your address so we can collect biometrics. So this is kind of like a new, very, very new RFE, and again, and that's why we've been like trying to like educate people on social media that rules are rules. We need to follow the government rules, and one of the government rules is AR11. AR11 means if any time your address changes, you have to notify the government immediately within 10 days. And I think these kind of RFEs, I think we're getting it because sometimes the AR11 is not updated, or sometimes there can be some pending charges. Like in this case, I think the poster feels that there could be a pending misdemeanor charge, and they want to do some more thorough background checks. So that is a possibility. And again, you're not the only one, because I did see two just in the last 1 week. First time I've seen this kind of an RFE. So we've been telling people update your AR11 immediately, because that's a mandatory rule. People tend to kind of overlook it. Okay, so that's very important. That being said, answer this RFE with your address. And when you answer this RFE with your address, what's going to happen is USCIS will take your biometrics, and they will use it to do more thorough background check on you. And they just want to make sure you don't have any crime that will make you removable, because there are enumerated crimes, like crimes such as crimes of moral turpitude, and so some kind of crimes where it's a big no-no. You do it, you could be put in removal proceedings, and they're going to do a background check. And if you do not have those kind of crimes on your record, more than likely not have a problem. So again, the thing is, immediately follow that. Try to answer that RFE as quickly as possible. Give the address back to USCIS, and let them do the biometrics. And if they really find that there is adverse information, what will happen is you will get another notice from USCIS, because we have seen that in the past where somebody has an arrest record. They'll come back and say, it looks like you've been arrested, for example. Produce all the police certificates, produce all the court records, and so on. So maybe this is a harmless RFE, we don't know. But what it means is USCIS wants to do a little bit more background check. At this point of time, I will not worry. But if you have something adverse on your record, some kind of a criminal infraction, immediately check with the police department, the court, and try to get all your records handy. Because if at all USCIS requires them, you can immediately produce it at a later point.
Okay. Very interesting. Thank you so much for this, for taking this up for Nandini. I think we just have not answered the last part, which is if case dismissed without conviction, will it still impact?
So if the case is dismissed without a conviction, what that means is you went through the court system. Yes, probably you were arrested, probably. But then when you went through the justice system, the courts proved that you're not guilty. So if you have that evidence from the court saying that the case is dismissed without a conviction, without pleading guilty, there is no immigration conviction, then normally you'll not have a problem. Because I had cases where people got arrested, and then eventually the court dismissed the claims, and the court said, no, you're not convicted. The charges are dismissed, charges are dropped. Then USCIS does not have a problem. But because they don't really have access to some of those records, sometimes what they do is they want you to produce those records and tell them what happened and what was the final outcome. And they do give defense to the court order. The court order is very, very important. So definitely get that judgment, and the judgment has to be signed by the judge. So in your case, if the case is dismissed, you should have a document from the court signed by the judge. So make sure you have access to that document And if you have a case where the case got dismissed without a conviction, I don't think you'll have any problem at all. Maybe a little bit of inconvenience, such as this RFE, where you have to prove it. But if the case is dismissed, you're not convicted, I think you'll be fine.
Thank you. Thank you. That sounds like good news. And Nandini, thank you for your question. This is one of the latest RFEs that are being addressed. So thank you also, Chand, for taking this up and for giving us the detailed information. Let's now take up Catherine's question. Hi, Chand. I'm currently on an H-1B visa, and a few weeks ago, I switched projects within the same company without informing my immigration team. I just found out that even internal role changes can sometimes need an H-1B amendment. I had no idea. What should I do now? Can this impact my visa status or future extensions?
I mean, again, I think if it is less than a month, I think most of the time you won't have an issue. And again, at this point of time, how do we fix it? There is a human error. How do we fix it? Immediately, like, have your employer do some analysis, because again, just because you change the project does not mean there is a problem, because you can change assignments, but you have to do an analysis and see if it is a material change. For example, somebody is working for a third party client in Dallas, say for PepsiCo. They change their assignment, and again, for the same role, say they go to a different client again in Dallas, say Verizon. That is not really a material change. So your company should do the analysis right away and see if that role change or the project change is material. Sometimes it is not even material. If the job duties are same and the work location did not change, it might not even be a material change. But again, because you have this change, check with your employer, with their immigration team, and see if it is a material change. And if it is a material change, even if it's delayed, file the amendment as soon as possible, because if it's a human mistake and you file this case before USCIS catches you, sometimes they'll give leeway, and most of the time they do give leeway. So our goal is, if it is not a material change, you're fine. There is no need to file a amendment. But if the company and your immigration team determines it's a material change, at this point of time, to fix the problem, file the amendment right away.
Okay, that's very important. Just so that, there's no misrepresentation of any kind. It's always best to stay safe and update every little thing. And especially if you're confused, ask your immigration attorney. That'll be best. It's best to, be guided by them. So, friends out there, if you need to have a consultation on your case as well, if you need to have an attorney, why not contact attorney Chand Parvatheneni? And his number is 817-523-8247. You can note it down. It's there on the screen below. And also, you can email Chand at law@spblawfirm.com and go visit www.spblawfirm.com to get to know more about Attorney Chand Parvatheneni and SPB Law Firm. So, also, yes, don't forget to subscribe to our channel because all this content is so much good information for you and free of cost. And all we need is your support as well. So, if you haven't as yet subscribed to us, subscribe now and also share our content with your friends and family out there who will also benefit with this awesome immigration content to keep each one of you updated. So, thank you once again, everyone, for joining us. And now we have Rag's question. Rag is asking, how does USCIS view H-1B petitions filed through an EOR, employer on record option?
Not sure I understand employer on record. But again, when you talk about H-1B employer, I'm not sure what employer on record option is. I have not heard that word, employer on record. But in
No
general,
worries.
a company will file for H-1B either as a transfer or as a new H-1B. If it's a new H-1B, typically you come through the lottery system, and then the employer will file. And again, if it's a transfer, somebody already has a H-1B, so they're cap exempt, and the employer can do a transfer. So these are the normal ways a company will file H-1B. And when it's an employer on record, I don't know if you mean somebody's working on OPT or somebody's working on EAD card, and then the company is filing a H-1B petition. If that is the case, normally there should not be any issue.
Okay. Well, thank you, Chand, and thank you, Rag, also for your question. So we will take up some more questions from our Facebook group, Chand, if you are ready for them.
Hmm?
But also,
Sure.
meanwhile, if you can tell us more about, when it comes to salary compliance for H-1B workers, what are the key wage rules these employers need to know and what could land them in trouble?
Sure. So wage compliance is probably very, very important, and if the wage compliance is not maintained by the employer, they get in trouble with Department of Labor. They get in trouble with USCIS, and sometimes probably even with Department of Justice. So wage compliance is very important, and what that means is the companies, they have to pay the highest wage between the actual wage or the prevailing wage. And what that means in simple terms is you have an LCA, and they have to make sure the appropriate wage is determined, not any random wage, but an appropriate wage. And how do you determine the appropriate wage? So you have to look at the requirements for the job. How many years of experience does your job require? What exactly are the terms of your occupation? What is the right ONET code? Because you have to calculate the salary based on the ONET code. So these are the things that are very important, and the employer will have to come up with a wage. And if that wage is not paid to the employees, it's a big problem. We do see this issue a lot. Sometimes employers accidentally pay less salary because sometimes the employers do an amendment or do an extension. They don't realize that the LCA salary has changed. That is one place. Another place I see a lot of issues, major issues, are benching. Benching is very, very highly illegal, and the authorities, if they find benching, it is a very serious issue. And sometimes, unfortunately, if the company benches an employee, tomorrow the employee is stuck because to do an H-1B transfer, employee will require pay statement. So sometimes employees, without their fault, if they're benched, their transfer is jeopardized. So benching is something that is going to cause a lot of problems, and benching is illegal. So the minute employee enters into the H-1B status, the employer has to pay the salary. If the employer does not pay the salary, the employee's status is getting jeopardized. Employer also is jeopardizing their own company, because these things will come out down the line. Somebody's going to complain, or there's a site visit, and the company gets audited, and tomorrow the penalties are very, very huge. So if the employer cannot simply say, I'm putting them on unpaid training, I'm putting them on orientation, because that is bench. So the salaries are super important, and wages should be paid in real dollars, like real cash. You cannot simply say, I'm giving them that benefit, I'm giving them that stock option, I'm giving them meals. So that is not allowed. So if the company says in the H-1B petition, this is what is the salary, we're going to comply with the LCA, the companies are expected to honor that and pay the actual salary, the actual dollars. Not simply say we're giving them some benefits such as stock options and that will add up to that amount. That is not allowed. And then the work location also matters. If somebody says my employee is working in Dallas, but the employee is actually working in San Francisco, the salary in San Francisco is a lot higher than the salary is in Dallas. So if the company is making somebody work at the wrong location and telling USCIS, no, my employee will work only from this location, and paying a less salary because that salary is low, that's again very, very, going to be an issue. And then timely payment. So a lot of companies, sometimes they pay very, very irregularly. They pay after 3-4 months after the work is done. So irregular payrolls are going to cause a problem. If there is ever a DOL audit or a USCIS site visit, it is going to get company in the trouble. So timely payment is something that is highly important. And deductions, always, everybody, the company should be looking at the paychecks, the pay slips for the deductions. Employee also should be monitoring your paychecks for the deductions. Employers cannot deduct things that they cannot deduct. For example, things like the H-1B petition fee, the fraud prevention fee, etc. Employer cannot deduct those legal fees, or employer cannot deduct any other fees that is not authorized by the law. So the deductions are very important. Always look at your deductions, and any unauthorized deductions are not allowed. So the bottom line is wage violations can cause trouble to the employees, to the employers. So always both the employers and employees make sure things are done right. And what that means is no underpaying or benching of any H-1B employees. Benching is not allowed. Companies cannot do that, and companies cannot use inappropriate, the wrong wage levels. Wage levels have to be appropriate. Make sure whatever is in the LCA is 100% accurate, 100% complied with. Okay, so again, bottom line, LCA is super important document. Always look at the LCA document. Everybody should comply with it. Not complying with LCA could get you in trouble with a lot of departments, Department of Labor, Department of Homeland Security, through USCIS, and so on. Okay, so be very, very careful, and penalties will be back wage payments that the employer will have to pay, civil fines to the employer that employer has to pay, debarment from H-1B program to the employer, DOL audits where the employer will be penalized. So to avoid it, employers should always be careful about these kind of things.
Wow, thank you so much, Chan. That was good information and very insightful. Thank you so much for taking each one of these questions already. And friends, I hope you are enjoying this session and resonating with each of the explanations, the detailed explanations we are receiving from Chand. So if you haven't as yet subscribed to us, subscribe now. Our handle is at Immigration Talk Show. Check us out not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. And now we do have some of our comments that we would like to address, Chant, and these are picked up from our YouTube and Facebook groups mostly. So let's take them up. Helen is asking, "Hi everyone. My employer applied for my H-1B in January and I got approved last month. I applied for change of status for my spouse from F2 to H4 when with the I-539 from, sorry, with the I-539 form online 3 days after my employer filed my H-1B. Currently, the I-539 form is pending. I received the receipt notice for the I-539 form online in the account, but never received it in email. Is this normal? Will they send the receipt notice through mail for form I-539? I checked the address I put in there and it is correct. Anyone experience the same? What do you do?"
Sure. So the good thing is, since he has a receipt online from the online account, at least that should be able to satisfy the requirement about proving that the filing was done timely. And more than likely, they should not have any issue. They don't really require the original; even that copy is fine for that I-539 receipt. That being said, it is very easy. So if you go online and there is an online chat that you can do with, it's called the Emma chat. So if you go online to uscis.gov, you can chat, you can do a live chat, and you can create a ticket and you can ask them to resend it because you missed that notice. So the easiest way is just go online, do a live chat, and let USS person know that this receipt is missing. You should be able to get a copy of the missing receipt. They might take time because sometimes these things take a lot of time, but they will send it. That being said, luckily, because this is an online filing, you do have a copy of the receipt. So at least temporarily, you can use that for all purposes, all immigration purposes. But I would encourage you to go do an online chat with Emma and then ask them for resending that copy back to you.
Great. Thank you so much, Chant, for taking that up for Helen. All the best, Helen. Now let's go on to the next one. This is from an anonymous participant. "I am exploring the EB5 option since my child was not born in the United States. We have initiated discussions with EB5AN and Bearing. I would appreciate hearing about real life experiences and reviews. I'm willing to share my personal details privately, but I prefer to remain anonymous when posting."
So I think I definitely encourage people, whoever can afford it. EB5 is still a great option because it's an act that is passed and that is valid till 2027 September. So even if we are hearing talks about gold card, so the gold card is like a different process. So EB5 is still going to be there at least till 2027. And anybody that invests money into EB5 before September 30th of 2026, they have this protection of being grandfathered. So EB5 is still a good option. People should look into it. So there's two things: EB5AN affiliate network, EB5AN and Behring. These are two regional centers out there who do EB5 projects. There are many companies like that who do EB5 projects, and EB5AN and Behring are one of those. What I would suggest is, because these are again valid regional centers, but again, is your investment safe? Is it a good investment? Because you're putting that money and eventually you want to make money out of it. You're putting your money at risk. And when you put money at risk, it all depends on how your project does. If your project performs well, you'll make money. If your project does not perform well, you might lose money. So what that means is you would have to do a lot of analysis and see how much risk you want to take. Because end of the day, it is that money that you have, 800K, you're wanting to invest in this project. And at some point, you are taking your own informed risk. So, for example, Behring, for example, they have a project happening in California, for example. Uh, I mean, is it? I mean, what does your gut feeling say? Is it you? Do you feel that eventually this project will make money or not? So that is something what you'll have to do. And it's good that you're already looking at two companies, because you're not looking at one, but you're looking at two regional centers with multiple projects. Both these companies have multiple projects. So do more research. And if you feel as an investor that, yes, there is a possibility of making good returns on this, I would say go ahead. That being said, these are companies that have been on EB5 for a long time. So you can, I think these companies are more than willing to share their track record with you, how many cases they have done, how many people have already got green cards, how many people are in process or got. So the first thing you should always ask in EB5 is, do you have a 956F approval? And do you have any 956, sorry, I526E approvals? And these companies will be able to tell you that information. And that will kind of at least give you a starting point on whether this is a project that you want to invest or not.
Okay. That's very interesting, Chan. Thank you so much for taking that up. Now let's go on to this next one. I have E2 visa sticker on my passport. Can I apply work permit card?
I am not sure. I don't do a lot of E2, so I'm not really sure. I probably would have to do my own research on
Okay,
this.
thank you, Chan, for taking that. Now let's go on to this one. My H-1B was picked last year and approved under consular processing. My STEM OPT is ending later this year, and I'm looking to transfer my H-1B to a new company or consultancy that can do the transfer under CapGap. This is very urgent. Please let me know if you can help.
So looks like he already has an H-1B, but it is approved under consular processing. So his H-1B is not yet active until he goes for stamping or somebody else files a change of status H-1B for him. So again, the way he will be able to work on H-1B is he can go through a transfer. So if he has a bona fide offer from another US company, that company can use his old consular approval and they can file for a transfer. So I think the main thing is, I think he needs to find a legitimate employer who has a bona fide job. If he finds an employer, he can simply use his previous approval, previous consular approval, and the new company can do a change of status. And that way, once that case is approved, without going out of the country, he can start on H-1B.
Okay. Thank you, Chand. Thank you for taking that up. And we have another question. This is also from an anonymous participant. Hello, has anyone recently used premium processing for their I-765? I really appreciate it if you could share how long it took for your EAD card to be delivered.
Sure. We do a lot of I-765 premium processing for like the STEM OPT folks. So again, when you upgrade your case, two things will happen. One, the case will get approved, and typically it is less than 30 days for 765s, or you get an RFE. So if you get an RFE, it'll delay the process. If you don't get the RFE in less than 30 days, normally I see a lot less than 30 days. So in about 10-15 days, you can expect. But again, for 765s, it is 30 days, not 15 days. So you'll get, at least you'll get an answer. Either the case is getting approved or the case is getting an RFE. If the case gets approved and you see an online status that says your case is approved, typically in less than a week, the card should be delivered to you. If you get an RFE, look what that RFE is, try to answer it very quickly. And then once you answer, again, in less than 30 days, you should see uh, the result. Okay. But the case is approved, less than a week is when you can expect the card to be delivered.
Okay. That's good news, I think. So thank you, Chand, for taking that up. And I think we do have another one. So this is from Noah. I applied for my green card form I-485 based on my approved asylum case. USCIS received my I-485 on November 1st, 2024, and my biometrics were taken on November 26, 2024. On January 16, 2025, they issued an RFE, and I submitted my response on March 15, 2025. However, the USCIS tracker still hasn't updated to show that they have received my response. I It's been almost a month now. Is this normal? Also, I might need to change my address soon. Would that cause any delays or problems with my case? I'd appreciate any insights from others who experience something similar. Thank you in advance.
Sure. So recently we heard this from USCIS that all the asylum cases, asylum-based 485 cases, they're going to be put on a pause, and they're going to kind of go through them a little bit in a more thorough fashion. So asylum cases are the only 485 cases so far that I know that are getting slowed down. So again, that probably could be the reason why you don't see your response status updated. That being said, the easiest thing is call USCIS or maybe talk to them on the chat, on the online chat, and confirm if your response is at least in their system. So just call USCIS or talk to them online and try to at least make sure the response is submitted. That is one part. And the delays are probably because the asylum cases are being slowed down. And regarding the address change, everybody, not just people who have filed 485, but anybody that is a non-US citizen, even if you're on a green card, there is this AR11 address change form that you have to file within 10 days of the address move. So even if the alien registration again is not for everybody, because some people are automatically registered in the new alien registration program, but this AR11 is something that everybody has to do. So in your case, if you have an address change, the minute you have the address change in less than 10 days, go online, go to USCIS, my USCIS account, notify USCIS about your new address. Okay, because everybody needs to update. If you're not a US citizen, you have to make sure USCIS knows your address. That is mandatory. There are no exceptions. So make sure you go to USCIS website and do the AR11. And if you do an AR11, and in your case, since you have a pending application, put in that receipt number, and you'll not have any problem. Changing your address will not slow your case down.
Okay, okay. Thank you so much, Chand, for taking this up for Noah. Now, this is the last one that we're going to take on. Hello, everyone. I'm a green card holder since October 2022. I filed the I-130 for my son in November 22, and still in cases being actively reviewed by USCIS. Please help me if you know what to do. Thank you so much.
Sure. So the I-130 cases are unfortunately taking a very, very long time. And if you look online, currently they're talking about 2+ years of timeline for immediate relatives. So again, if you're a green card holder, you come under the categories. So you come under one of those the family-based categories. So anybody that's on a family-based categories, we are seeing I-130s take a very, very long time, and it's pretty normal. So I-130s could take a long time, and if your date is current, at least you can kind of try to call USCIS and try to expedite your case. But if your date is not current, this is kind of anticipated. This is kind of normal. So if the date is not current, even if they approve the I-130, technically you cannot file a 485. So if the date is not current, this is a very normal thing. We do see I-130s take a very, very long time. A couple of years is probably what they take. If the date is not current, if you're one of those family-based categories where your date is not current, I would say that this is probably pretty normal.
Okay, that's very interesting too. Thank you so much, Chand, for taking this one as well. Thank you for taking each of our questions from our, live viewers and also from our Facebook comments. Thank you for taking each one of them. Oh, we have this one last one from Rag. Can showing spousal income go a long way in pay or salary issues?
No, because say, for example, you're on H-1B and your employer is paying you uh, less salary than what is required as per the LCA. So even if your spouse has a good salary, again, she has independent status, maybe H-1 or maybe H-4. So the statuses are different. So if your spouse is making good money, again, yes, you're going to show the income and pay the taxes. Again, it proves that you are good. People like paying valuable taxes to the government. So as a whole, yes, it'll make your family's case stronger when eventually get to the green card stage. But in terms of like if you're talking about you having an H-1B, will the spouse's salary make anything different? Probably not. But again, you're making more money and you're paying more taxes. Eventually, it makes a good case. USCIS, when they review your case for anything, they know that you're hardworking people. You're contributing a lot in taxes. So definitely, that'll give you an edge because that's what they want. People like you who are hardworking and you're making good money, contributing to the society, contributing to the taxes. So yes, it is definitely an added edge. But in terms of your immigration status, again, if you're on H-1B, you're supposed to follow the H-1B regulations, which means paid as per the LCA. If you're on say F-1, you have to follow what the F-1 requires. So everybody's status independent, and we need to make sure we are following the requirements of our own legal visa status. But then in the family as a whole is having good income, I would say as a whole, it'll definitely give a good value to you as a family when you apply for green cards or go for stamping. Because when you go for stamping, sometimes they ask for your tax returns. So it makes a psychological impact. they see your tax return whenever they see that you're contributing well to the economy.
Okay. Well, thank you so much, Chand, for taking this up as well. And Rag also says, thanks, Nipa and Chand. See you next. Thank you, Rag, for your questions. And I hope you've gotten all your answers. We'll keep watching out for you too, for you to join with your questions. And not just Rag, each and every one of you. Thank you so much, actually. You made this show even more interesting with your questions, your cases, and so much more information we could get through chance today. So don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out on YouTube, LinkedIn, Facebook, and on X as well. And stay in touch with us. We are on Instagram, so check us out there also. But Chan, do you have any more time left, maybe to spend with us, maybe 2 more minutes or so? I would like to take up a case study if that's
Sure.
fine, just before we leave.
Sure, sure.
So, I mean, this is about multi-location work for H-1B employees because nowadays with work from home and everything. So Raj is an H-1B employee working as a software developer for a tech consulting company in New Jersey, and his original H-1B petition listed the company's main office as his work location. And recently, Raj has been assigned to a long term client project in New York City and is required to work from the client's office 3 days a week. So occasionally, he also works remotely from home in Pennsylvania. And well, the question is, given that Raj's new work situation across multiple sites, what steps must his employer take to remain fully compliant with H-1B regulations? And does this trigger a need for an amended petition or other formal updates?
Sure. So anytime somebody is doing something that is different from their LCA. So for example, in Raj's case, we have a location in New Jersey. So now the minute Raj or his employer realize that, hey, something different is happening. So in this case, the work location, a new work location is getting added. So anytime this happens, everybody should do like an analysis. And that analysis is this work location and that work location in the same metropolitan statistical area or not? If it is in the same metro area, pretty much all the employer has to do is you just post the LCA at the new work location. You just have to post the LCA because it is in the same metro area, and you don't need to file an amendment, and you can continue working. But in case we determine that the metro areas are not the same, it's a different metropolitan statistical area. This is a different metro area. Then we have to make sure that we not only file the LCA, but we also file the amendment, the H-1B amendment. Once it is filed with USCIS, only then you can start. So in this case, again, you do an analysis, you look at the zip code, the county for the New Jersey, look at the county for this particular place in New York State, and then see if it's a different metro area. If it's a different metro area, always file the amendment. Uh, and then move ahead. Okay, so it's a good question, and everybody. That's why the thing is, the minute you know there's a change in what's on your LCA, you immediately have to do this analysis and see if it is a different metro area, or is anything materially changing with your job. If so, file the amendment. If not, if you determine no, there is no material change because they are very very close by areas, same within the same commutable distance, same metro area, you don't even have to file an amendment.
Okay. Very important points to keep in mind. Thank you so much, Chand, for addressing this as well. And with that, I'll not keep you waiting anymore. But if you could just wrap up this session, since we spoke about such interesting points, both for H-1B and for, students as well. So if you can just wrap up to let folks out there watching
Yeah.
us, any tips or something you can leave them with to keep in mind.
Sure, sure. I think at least what we have seen with the students in the last 10 days. And so I think the lesson for all is, I mean, always we need to follow the government rules and regulations. And what that means is no small infraction is a small infraction. Even if it's a small offense, it's still an offense. And because end of the day, government makes the rules and we have to honor it. And what that means is this is a good time for everybody to kind of uh, reanalyze and make sure you have 100% clean track record. Okay, so that means no traffic incidents, no public intoxication, never drink and drive, shoplifting. So shoplifting again. Sometimes some people come back to me and say, "Hey, it was accidental. I didn't even notice it was in my cart," because it could be accidental. What that means is the lesson for us is we have to be overcautious. So if you're going to a grocery store to do some shopping, always don't be in a hurry. I mean, always make sure you're not putting things in the cart accidentally, because sometimes even if it's an accidental mistake that something was in your cart, tomorrow the grocery store will say that it is shoplifting if you don't pay for that item. So a good time for all of us to understand that it is zero tolerance, and what that means is no crime is small crime. I mean, a mistake is a mistake, and what that means is, I mean, as much as humanly possible, we should always ensure that you're not committing any mistakes that violate any rules or regulations. And I think just being more cautious and trying to follow the laws is what I think we should do, and then that'll keep everybody out of trouble.
Absolutely, Chand. Thank you so much, and great advices to be better people. I mean, on the streets and wherever you're living, actually. I mean, drinking and driving anywhere could be dangerous. Maybe you may not think much about yourself, but for the other person, please think twice, because it's other people's lives and property is also at risk. So take care of that. I know the weekend is coming, and probably tomorrow is going to be a fun Friday for most of you, but yes, I think it's best to make plans for sleepovers than driving back from your party. So take care of that. And thank you so much, Chand. Once again, I had a great time chatting with you today in our session. Very, very insightful. I wish we didn't have to cut this short. But yes, thank you so much once again for joining us.
Thank you, Nipasa.
Have a great day, Chand. And folks out there, you can also contact Attorney Chand Parvatheneni, and that you can do by calling him up on his number 817-523-8247, and his email address is law@spblawfirm. And definitely go visit www.spblawfirm.com to get to know more about Attorney Chand Parvatheneni and also SPB Law Firm. Also, friends, if you haven't as yet subscribed to our channel, I really hope that you did resonate a lot with today's session, and check us out, because we have so many other information that you don't want to miss out on, because especially that we have been having so many updates lately with regard to immigration. So stay updated, and stay tuned to our channel as well, because there's more coming in. So our handle is at Immigration Talk Show. We are not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. And also, you can contact me if, in case you want to message me or call me up directly. I have a phone number which you can note down: 408-335-6444. And this is also my WhatsApp number. So you can leave a message there. And maybe when we have another session again with attorneys, we can address your question. Or you can email me at nipa@staffingly.com. So thank you once again, friends, for joining us today. I had a great time, and I hope that you too did. So have a great day ahead. Bye for now.